Third Geneva Convention defines the status of a prisoner of war as a soldier, volunteer, or non-combatant who was captured by an enemy during any armed conflict, even if this conflict is not recognized by one of the parties. POWs under the convention must fit the following criteria. When captured, they were wearing uniforms with identifying insignia. They were not using prohibited weapons or chemicals or firing at civilians. That is, they have not committed war crimes. On November 25, 2018, near the Kerch Strait in the Black Sea, the Russian military seized 24 Ukrainian sailors after attacking their ships. The tugboat Yanni-Kapu was rammed and the Berdyansk was shelled. Another ship, the Nikolai, was also captured. The ships and sailors' uniforms were clearly marked with the insignia of the naval forces of Ukraine.
For the first time in 5 years of the so-called hybrid war, an open act of military aggression, of armed aggression, on the part of Russian servicemen against Ukrainian servicemen occurred. The sailors themselves stated that here in Ukraine, they are considered prisoners of war. The rest of the world considers them prisoners of war as well.
The convention does not require any confirmation of the status of prisoner of war.
They are already de facto prisoners of war. The European Court may admit that Russia's failure to provide this legal status is a violation of the Convention. In any negotiations, the decision of the European Court will have a lot of weight.
Prisoners of war cannot be interrogated under pressure, imprisoned in any pretrial detention center, or tried in a civil court. The convention prescribes the living conditions, food, and medical care that cannot be worse than in the military of the country that captured the prisoners of war. The POWs also have the same rights to communicate with the outside world, as well as the protection and visits by representatives of the Red Cross.
The violations that are recorded include the right to an unbiased and fair trial and a violation of the right to defense, since the first interrogations took place in the absence of lawyers. In addition, the sailors are kept together with the prisoners in a general manner, and their military uniforms were removed from them. We also checked all facts pertaining to psychological and physical pressure, attempts by the aggressor country to impose its position.
This video provides one piece of evidence that shows Russia violating the prisoners' treatment convention: interrogation without lawyers and coercion to confess guilt. Russia is trying Ukrainian sailors as criminals. By not recognizing them as prisoners of war, the Kremlin is violating the norms of its own constitution.
Within the meaning of Article 15 of the Constitution of the Russian Federation, international treaties to which the Federation is a party, their norms take precedence over the norms of national legislation, and therefore we rely directly on the norms of the Geneva Conventions. Russia wants to dilute this status in order for the sailors to not be recognized as prisoners of war, because then very clear rules of law are in effect. Russia would have to unilaterally release them, and this would be foolish for Russia.
Unconditional release is required after the cessation of hostilities, and also in the case of serious health conditions that any prisoners may have. Parties to the conflict may come to an agreement in special cases, and it is also permissible to let a POW go on parole on the condition that they will not take up arms again.
As the capture of these prisoners was a political decision, their release should also be solely the result of a political decision.
Crimea's prosecutor office in exile is collecting evidence against those who detained the Ukrainians. Under Ukrainian law, the guilty parties face between 8 and 12 years in prison, and the verdict may be made in absentia. Reported by Yevgenia Burda, UATV.